In 2018, the Supreme Court ruled on a complex and controversial case called Ohio versus American Express. That case had significant impacts on the antitrust world, and particularly regarding the definition of a two-sided market. Hello and welcome to Talks on Law. I'm Joel Cohen. Today we're joined remotely by Julie Elmer of the law firm Freshfields. Julie, welcome to Talks on Law.
Thank you, Joel. I'm glad to be here.
We're talking about Amex today. It's a controversial case. Maybe explain to the audience why if they don't already know.
Sure. So this case involves a concept that is very important in antitrust law, and that's market definition. So the plaintiff in an antitrust case needs to be able to define the market where the defendant is allegedly harming competition. And without a properly defined market, it's tough for a court to determine whether or not a defendant's behavior has actually harmed competition. And the American Express case began about a decade ago in 2010.
One thing that we might not think of is that these cases last so long, or it takes so long for them to get to the high court, that it may be an entirely different DOJ that brought the original case than the one who is involved in the Supreme Court review.
That's exactly right. So, in 2010, the Obama administration was running the DOJ. And of course, in 2018, that was under the Trump administration. And it was actually the group of states that took the case all the way to the United States Supreme Court. So the states and the federal government had won at the trial court level, and American Express appealed to the Second Circuit. And then the case went up to the United States Supreme Court.
What were the specific allegations, I suppose, in the case that were seen as anti-competitive by the lower court?
If a merchant wants to be able to use American Express cards, its contract with American Express required it to accept an anti-steering provision. And what that means is when a customer comes into a store and is about to buy something, the merchant is not allowed to discourage the customer from using an American Express card. And the reason a merchant might do that would be to avoid the fee that American Express charges merchants.
Which I'm not sure if this is still the case, at one point was a little bit higher than other cards.
That's exactly right. And one of the reasons for that is that American Express provides its cardholders with pretty robust benefits. You can earn miles. There are other benefits that consumers had. And so that was the point of the case, is that the government was focused on the merchant side of the case, the harm to merchants. But it wasn't looking at the other side of the transaction platform, which is the consumers. And the consumers who were using the card were benefiting because the loyalty program.
This is the two-sided market that Justice Thomas rested the decision on?
Yes, that's right. So Justice Thomas explained in the majority opinion that what American Express is actually selling are transactions. And one feature of what American Express was selling was something that's called simultaneity. So it is selling to merchants some transactional services at the same time that it is selling a consumer transactional services. And this is happening simultaneously.
That all seems fine, but I suppose it comes down to how do you define what a two-market platform is?
Yes, so Justice Thomas recognized in his opinions that not all two-sided platforms should be treated the same. There are certain types of two-sided platforms called two-sided transactional platforms, and the credit card services is a great example of what a two-sided transactional platform is, where what is being delivered via that platform is a transaction. And so the element of simultaneity exists for those types of platforms.
Two-sided transactional platform, that sounds like it could be a credit card company or a tech platform like Uber or Amazon.
A two-sided transactional platform can encompass a lot of technology platforms, a lot of financial services, but taken to the logical extreme, almost anything could be a two-sided platform. For example, there was a case that was filed in a federal district court in Illinois that was alleging that a group of dental insurers was engaging in anti-competitive practices. And the dental insurers argued that the complaint did not properly define a relevant market because the dental insurance industry is a two-sided transactional platform. And the district court in that case rejected that argument. And they rejected the argument because consumers pay insurance premiums for insurance, say, every month. But that doesn't correlate with when the consumer is going and visiting the dentist. They might not even visit a dentist at all in a particular year.
Maybe we need to understand what the two sides are. Is it the dentist has two partners on each transaction? One is the insurance company that's paying, and the other is the actual client who's in the dental chair?
See, that would be a way of taking it to the extreme, right? But in this particular case, it was the dental insurers that were arguing that, hey, we are operating a two-sided transaction platform. We are connecting dentists on the one hand with consumers on another. And the court did not buy that argument. They said, look, you don't have the element of simultaneity here. The consumers are paying their premiums every month, whether they go to the dentist or not. And then you guys, when you reimburse the dentist, your reimbursement does not correlate with the patient's payment of a premium. It correlates with the dentist's provision of services.
I mentioned in the introduction, this case has been controversial. So far, you've explained some interesting antitrust issues that it raises, but what's the meat? Why are practitioners and the antitrust bar up in arms about it?
I think the reason why a lot of antitrust practitioners are talking about the American Express case is because a few of the lower courts that have interpreted it so far have applied it in a way that could have far-reaching consequences for antitrust law going forward. This particular case, the American Express case, was a case involving an agreement between firms at different points in a supply chain. That's called a vertical agreement in antitrust law. So the case that Justice Thomas, the majority opinion addresses, did not involve, for example, an agreement between two competitors. That's called a horizontal agreement. Those are generally bad. It did not involve a firm with monopoly power, and it did not involve the merger of two competitors. And so taking American Express and applying it to fact patterns that are different from the fact pattern of that original case might be problematic for antitrust law going forward.
Let's talk about how some courts have applied the Amex case. What have you seen in lower courts since?
So the majority opinion in American Express says that only two-sided platforms can compete with a two-sided transaction platform. And I think that's the statement in the opinion that can have far-reaching implications for how antitrust law is interpreted going forward. And I'll give you an example. There was a case called U.S. Airways versus Sabre. It was a case in New York federal court, and there a jury found that Sabre, which is a travel technology firm, had violated antitrust laws because it had forced certain contract terms on its customer, U.S. Airways, which now is American Airlines.
In that case, a court applied Amex. How?
In that court, the jury found that Sabre had violated the antitrust laws because it had harmed the airline. But Sabre argued, hey, you shouldn't just look at the airline side of things. We run a transaction platform here, and we connect airlines and travel agents. And what you need to do, judge and jury, is look at how our contracts impact the travel agent side of our platform. When we charge higher fees to airlines, or we require airlines to use our platform, we have better quality product that we're able to offer to the travel agencies, and we're able to pay the travel agencies higher incentive fees for using our product. And so when you balance the airline side of the platform, the impact on the airlines with the impact on the travel agents, you get a net benefit overall to the way Saber's contracts operate in the travel industry. And so that was their argument. They wanted the trial court to instruct the jury to view the market as a two-sided market. But the trial court did not do that. And so the jury looked at it through the lens of a one-sided market. The jury found in favor of the airline, and then Saber appealed to the Second Circuit, and the Second Circuit held that the court should have instructed the jury to look at this as a two-sided market.
So Amex, as a case, is already controversial. What did Saber add in terms of raising questions or maybe confusion when it comes to this type of antitrust issue?
In the U.S. Airways versus Saber opinion that came out of the Second Circuit said that the market must include both sides of a two-sided transaction platform as a matter of law. And that phrase, as a matter of law, is really important because traditionally in antitrust law, market definition has been a fact question for the judge or the jury, whoever the fact finder is, to decide.
So while American Express was a new factor in antitrust law, Saber may be taking it even further.
Yeah, I think it took it further. It also added a word. So I'll read to you what the Second Circuit said. They said that the American Express court had held that in a case brought under the Sherman Act that involves a two-sided transaction platform, the relevant market must always include both sides of the platform. But the Supreme Court opinion doesn't use the word always. That's a word that the Second Circuit added. So in my view, the Second Circuit overinterpreted Amex.
How about other cases that may be interpreting American Express in a new way?
United States versus Saber is a merger case that was tried at the beginning of 2020. And in that particular case, Saber, so the same company that was involved in the litigation with US Air. And so Saber wanted to buy a small technology firm called Farelogix. And Farelogix offered services to airlines that were similar to some of the services that Saber offered to airlines. Farelogix, however, did not offer services to travel agents. So unlike Saber, Farelogix wasn't serving the other side of the platform. They were really only competing on one side of the platform. So the government sued to block Saber from acquiring Farelogix. And Saber argued at trial that, hey, we're a two-sided transaction platform. The Second Circuit has held as a matter of law that we are, and that only another two-sided transaction platform can compete with us.
Oh, interesting.
So even though all of our business documents say that Farelogix is a competitor, and we have our customers, our airline customers say that Farelogix is a competitor, you cannot hold that Farelogix is a competitor of ours because they are not a two-sided transaction platform. And the trial court bought that argument.
Did they buy it because of that as a matter of law quote that you mentioned from the Second Circuit?
So it was a combination of the American Express opinion, the Supreme Court opinion, and the US Air versus Saber Second Circuit opinion. Those two opinions are very prominently featured in the district court's opinion in US versus Saber. And what's troubling is that US versus Saber is a different kind of case than either Amex or US Air. So Amex and US Air both involved what's called a vertical agreement. Those are agreements between companies that are not competitors of each other. They're at different points in the supply chain. But in the United States case against Saber, what the United States was trying to do was block the merger of two companies that were, at least in certain services, horizontal competitors with each other under a different law. It's the Clayton Act, Section 7 of the Clayton Act. The other two cases were decided under Section 1 of the Sherman Act. And no other court had extended the Amex two-sided market reasoning to a merger case under the Clayton Act. So what the district court did really was taking the American Express opinion and expanding it, maybe to a fact pattern that really wasn't intended.
What was, I suppose, new or surprising about this district court case?
So there's a very long-standing precedent. It's called United States versus Brown Shoe, and it's a merger case that's been around since the 60s. It's an old Supreme Court case that's still good law, that was actually cited by Justice Thomas in his American Express opinion. And that case stands for the proposition that when you're looking at a merger, the proper antitrust market for purposes of assessing whether or not the merger violates the Clayton Act is, what do the real world facts on the ground, the commercial realities, show you? And the market should be defined around those commercial realities. It's really saying, hey, you look at the real world, you look at the facts on the ground. And so the fact that you have the Second Circuit saying that as a matter of law, you can't look at the facts on the ground if you have a two-sided transaction platform, that to me is a departure from over 40 years of tradition. 40, I'm doing my math wrong. 60 years of tradition in antitrust law.
And it also raises an interesting question, which is, can a two-sided market company buy up any one-sided market companies that it wants without any fear of antitrust exposure?
Joel, that's a really great question. And that was an argument that I made in my closing argument in the United States versus Sabre case.
Oh, this was back when you were a prosecutor?
That's right. Another concern that I have as a practitioner is that if American Express is misinterpreted to a logical extreme, that there's actually a risk of backlash. Because there are services out there and platforms out there that really are two-sided platforms and really should be viewed on both sides of the market. And if you have a lot of decisions where the decision has been overinterpreted to an extreme, you can have a backlash, and then the cases that should get the application might not.
Given the impact of the American Express case, has Congress taken a look at amending the actual underlying laws?
Well, so, there's been a lot of talk about antitrust reform lately. If you're reading the papers or listening to the news. And this summer, there were some congressional hearings about antitrust concerns. And then in October, the House majority put out a report that recommended some reforms to American antitrust laws. And one of the reforms that was recommended was a reform to overrule legislatively American Express. I think just given how the election results went, I think it's probably unlikely that we're going to have legislative reform like that. But I don't think we necessarily need legislative reform in order to beat back misapplications of American Express. I think the DOJ took a good first step in securing a vacatur of that district court opinion in U.S. versus Sabre.
Julie, Elmer, thanks for joining us today.
Thanks, Joel. It was great to be here. I really enjoyed speaking with you today.